Welcome, and our purpose today is to discuss product liability issues in the U.S. It can be a very disconcerting topic for those companies that are importing products into the U.S., and you hear from time to time horror stories. Of course, the one that everyone always talks about, which is often misunderstood, is the case of what? The McDonald's coffee, right? Everyone talks about that case. It's probably not, when you drill down and understand the true facts of the case, it's probably not the best poster child for product liability abuse. But there are plenty of others that can be cited for essentially horror stories of how companies have, without any ill intent, manufactured and distributed a very good product into the U.S. and been caught in the trap of very costly litigation. So what we're going to try to do today is to understand how these risks are created and compounded through acts or omissions of the company that is in the distribution chain. So it's my premise for this entire presentation is that there are very practical things that can be done to try to quantify these risks, approach them, through some sort of framework or matrix to understand where they're coming from. And although you can't eliminate them, you can, in some sense, mitigate some of these risks. When we talk about product liability, we can either use that in a broad sense or a narrow sense. In a narrow sense, we refer to a specific body of law that originated in California, by the way, about 100 years ago, that relates to a scenario in which a product has caused injury to person or property. A toaster causes a fire and a house burns down. A commercial machine chops off a finger. A product causes some sort of chemical reaction or causes cancer. Those are product liability cases in the narrow sense. But what we want to do is go beyond that narrow sense and understand essentially any liability that arises from the sale or distribution of the product. There's one sort of exception that we won't get into today, and that is, of course, there are liabilities in the intellectual property area, patents and trademarks, and to a certain extent even copyrights that can arise from a product. And that's a significant topic in and of itself, and we have a lot of material within what we are seeking to accomplish, and to include IP issues would be a little overwhelming. So we exclude that for today, but we're really going to try to discuss every other type of product liability potential or scenario that comes from the sale or distribution of products. Product liability claims arise within a broader framework of what I call the 5 C's of litigation risks. So I have the unfortunate duty to commiserate with clients who are caught in protracted litigation and try to help them out of the litigation problem. Although that essentially is how I make my living, I find it very fulfilling, even though it's somewhat against my short-term economic interest, to advise clients on how to avoid getting involved in a problem in the first place. And so in advising clients on this and speaking on this issue, I've come up with the 5 C's of risk litigation. And 3 of the 5 are going to be a topic of our discussion. So I just want to sort of set the table here and just briefly touch on these 5 C's of litigation. The first, which we won't be dwelling on, is of course the corporate formalities, the creation of the corporate entity. Here we have shareholder litigation, partnership disputes, failure to follow various formalities in the creation of the corporation. And that's, of course, of great interest to entrepreneurs that are starting a new company. But let's set that aside. The second is going to be of interest. That is the second C, and that is customer and consumer complaints and claims. So we're obviously going to be discussing lots of issues that relate to consumers. And of course, a common theme that you're going to hear throughout this presentation is there's a big difference between selling a product to a commercial entity and selling a product to a consumer. the consumers are endowed with all sorts of special protections that the commercial entity in the B2B context does not get. Of course, most of these products are sold pursuant to a contract or a series of contracts throughout the distribution chain. So contract disputes, the third C's of our 5 litigation C's, is included here. We'll touch on a fourth C, which is competitors' attacks. In the US, we have the Lanham Act. In addition, there are common law claims that are well suited for one of your competitors to bring a claim relating to what you're doing with your product, particularly if you're advertising your product, comparing your product to a competitor's product, kind of asking for trouble there in that situation. So competitors' attacks is the fourth C. And because I'm a sucker for a good alliteration and I needed to discuss employment litigation claims, which of course we won't be discussing, I had to come up with cogs in the wheel, a little bit of a forced term to make all the C's line up. But cogs in the wheel are employment cases, and of course they are a significant risk for any business. If I could just do a shameless plug here, in your materials I have an excerpt from a book that I'm writing called Swimming with the Sharks, and it is sort of centered around these 5 C's of litigation. And if I keep my shoulder to the wheel, we'll be out maybe next year. So, and if I tell a group of people that it'll be out next year, that at least marginally increases the likelihood that will happen. So, but the introduction and the first chapter, which sort of sets the table with this presentation, introduces these 5 C's and discusses them in a little greater detail. Our goal here is to create a risk mitigation plan centered on product claims, to create a framework to understand where these claims are coming from. And we have to understand that as the business evolves, this risk mitigation plan is going to have to evolve as well. You'll notice in the presentation that I'm going to talk about California a lot. And there are a couple of reasons for that. First of all, my familiarity with California, having spent essentially my entire legal career in California litigating cases involving California statutes, California doctrines. But secondly, California does represent what I like to refer to as the high watermark of liability in the US. There are cases that could only survive a motion to dismiss in California. There are regulations that could only come out of Sacramento, and they continue to churn each year. With the election of President Trump on the East Coast in Washington, D.C., we have this battle between East Coast and West Coast, or as I like to refer to it, left coast, in which there's deregulation taking place at the federal level, and California essentially viewing its role, as it always has, but even more so now, as a necessary regulator with its significant market share in the US, increasing the regulations in California, and by virtue of having this significant market, companies have to comply with California law in order to sell their products in California, and therefore they comply and adopt those changes for their products sold throughout the rest of the 49 states. So it's a really interesting tension that we have between left coast and east coast with respect to regulation right now. So we'll refer to California regulations quite a bit, but keep in mind that when you're selling products to other jurisdictions in the US, there are of course other state laws and regulations that apply. I will be discussing the usefulness of disclaimers, particularly when we get to the discussion about breaches of warranty. So I want to practice what I preach here and have my own very lawyerly disclaimer at the beginning of our presentation that no legal attorney-client relationship is created by this presentation, and you can read the fine print there on your own as well. There are 7 participants in the product liability risk mitigation effort, and we'll be referring to these throughout. But it's perhaps helpful as you begin to think about these issues or advance your own product liability risk mitigation plan to sort of use this as a checklist. The management, of course, is very important, making sure that you have buy-in from members of management. The R&D department that is creating and refining the product and designing it. Obviously, the insurers are very important. We'll talk about that extensively in a moment. All of the testing that has to take place. The sales and marketing, very critical, particularly when you talk about the risk relating to false and deceptive advertising, making sure that the product is not oversold in terms of its capabilities and specifications. Lots of products are a component of a larger product, or your product has components within it. And so we have components and vendors that are selling plastics or metals that you are putting into your product. That's a significant participant in the product liability risk mitigation plan. And then, of course, the chain of distribution, whether you're selling the product in retail brick and mortar stores in the US or in e-commerce, all of those are covered by a series of contracts that need to be assessed for indemnity provisions and so forth. And then finally, the customer service that is receiving the complaints of consumers about the product and needs to be aware that this could be the first warning light as to an issue that could develop into a larger, very significant liability. So to try to create a framework so we can understand these risks a bit more, I've divided these into categories of claims and sources of claims. And the presentation here is really going to focus on these 4 categories of claims that are listed. They all relate to potential litigation arising from a product. First are the product liability claims in the narrow sense of what I talked about before. Remember, it's it's bodily injury, which could include death, or injury to property. And there's a body of law that we'll unpack a bit about that. Then there are the breach of warranty claims, which are contract driven. And so we're going to talk a lot about contract terms, and again, the division between a B2B contract and warranties and disclaimers of warranties and a consumer contract. Very significant. They're opposite ends of the spectrum in terms of the freedom to contract. And then the third topic that we're going to address, the third category of product-related claims, is the advertising, deceptive marketing, and this is a significant area of consumer class actions in California and other jurisdictions as well. And then the fourth is something we wouldn't have included 20 years ago, but is increasingly a very significant issue, and that's consumer privacy and what you're doing with the data that you're holding. These 4 potential categories of claims come from a variety of different sources. And I have these listed here. So if we put these together, we have a little matrix. And I've tried to, some of these don't really apply. What I've tried to do is just give a sentence scenario with respect to how these product liability claims can come from these product liability sources. You can also refer to this, as I do, as product liability bingo. And so I put this on 2 slides, and in your material, there's a matrix under tab B, right here, so you can see the whole thing. And in the second page behind this, you'll see there's a completely blank bingo sheet that you can fill in on your own. So I think one of the first steps to grasping product liability claims is to sort of identify, using your Dorsey and Whitney branded highlighter that you've been given there, with a nice big X, maybe the top 3 squares within this matrix that the product liability claims may, sources of the risk and the types of the risks. And that will help you start honing in on the scenario that could be your next big potential litigation. Now, let's get right into the first of the 4 claims, which are the product liability claims that have caused injury to person or injury to property. In one sense, product liability is a very simple concept in that what happened about 100 years ago is the court simply said, we are going to dispense with the notion that a person that has been injured in their personal property by a product has to have privity of contract with the party that put that product in the stream of commerce. Before, when the toaster caused the house to burn down, there was no tort theory that allowed the owner of that toaster and the owner of the home to sue the manufacturer, because chances are the manufacturer had no privity of contract with the owner. The owner purchased or the product through a retail store, or it was a gift, or something of that nature, and so there was no contract, and therefore no liability. And about 100 years ago, or actually a little less than 100 years ago, in a case called McPherson versus Buick in California, the court just said, you know, as a matter of public policy, we have these companies putting out these products, they're causing not just inconvenience by not working, but they're actually causing injury to person or property. We're just going to allow a lawsuit to be filed on a tort theory, and we're going to call this product liability. And there are a number of obviously very complicated permutations and sub-theories within product liability, but that's it in a nutshell. The triggering event is placing a defective product into the stream of commerce that causes injury to person or property. There are three basic categories of product defect. And these can be pursued simultaneously, or the plaintiff can pick which of these types of defects he or she is going to pursue. There's a design defect, a manufacturing defect, and a warning defect. And we're going to break these down very briefly as time permits. Let me just digress for a moment here. When I'm trying to understand an area of law, or I'm trying to explain an area of law to a client, I find it very useful to use what we call the case, in California, the Casey instructions. Other places call it the form jury instructions. Now, I recognize in Canada that it's not typical to have a jury in a civil case, but in the US, juries in civil case are the rule rather than the exception. And so we have, whether we like it or not, juries of laypersons that are deciding multi-million-dollar cases, some involving very, very complicated technology and complicated transactions. And they have to be informed in layman's terms of what the law is. So I borrow from the Casey instructions quite extensively. And so I've included here the Casey jury instruction for design defects. What is a design defect? So this is what a jury would actually receive if your product was subjected to a design defect product liability claim, and the jury was forced to determine whether or not there was a design defect. I really want to emphasize on this slide and in this point the second set of considerations that a jury is required to take into consideration. This is a balancing test and involves a great deal of subjectivity. They are balancing the harm or the potential harm of this particular design with the feasibility of an alternative design, with a special emphasis on the costs of an alternative design. A plaintiff's lawyer in a product liability case that is pursuing a design defect theory loves nothing more than to emphasize that a small change, a insignificant from the manufacturing standpoint and a very inexpensive change to the product could have made it infinitely safer. And so this balancing test becomes very difficult from a defense standpoint when you can't disagree with that. When a $2 safety latch on a piece of equipment could have prevented this injury from happening. Obviously, you have to weigh against that the feasibility and whether it would make the product inefficient, that you couldn't really use the product. But in many instances, it can be a very inexpensive change to the product. So those are some things to think about with respect to design defect. Manufacturing defects are pretty straightforward. What makes these cases complicated is they often involve lots of different parties. It involves a third-party manufacturing that failed to conform the products that went out the door to the specification or to the prototype that was provided. And these are the jury instructions that relate to a manufacturing defect. Warning defects are very interesting. Warning defects presume, as all of product liability does to a certain extent, that the product will be misused, that the consumer will be negligent in how they use the product, that the consumer will actually do something really stupid. And so it's incumbent on the manufacturer to sort of anticipate those types of mistakes, stupid errors, things of that nature, and to put warnings. So a product that is otherwise safe in every respect, it was designed in a safe manner, it was not defective in its manufacture, can nonetheless be subjected to a claim just because it failed to have adequate warnings. The warnings may be labels, the warnings may appear in the owner's manual. Warnings can sometimes relate to chemicals, exposure to chemicals that could cause harm. And there are also warnings that sometimes relate not to when the product went out the door, but to knowledge that comes to the manufacturer after the product is out in the market and there are consumer complaints that start coming in, and all of a sudden there's really a reasonable company would have issued a bulletin, would have at least updated a website to issue some sort of warning after the fact. And in some instances, there's actually a cause of action under product liability for failure to issue a recall. California recognizes that a cause of action that's sort of a subsidiary of this failure to warn, which says even if you acted reasonably when you sent the product out the door, based on the information that you received after that fact, you should have done these things, including issue a recall. So those are the warning claims. The cost of product liability cases are significant, as this next slide illustrates. There are compensatory damages, including pain and suffering. Remember, we're talking about, in many instances, bodily injury, sometimes permanent, sometimes even wrongful death. There are punitive damages, which are designed to punish, not to make the plaintiff whole, but to punish and make an example of you so that others in the industry will avoid a similar result. The punitive damages can be up to 10 times the compensatory damages. When you start going over 10 times the compensatory damages, you start getting into some due process issues under the Constitution. But punitive damages, of course, can be significant. And that's how you end up with cases that hit the headlines with lots and lots of zeros behind them. Of course, the litigation cost can be significant. And then a product liability case often spawns other problems, other headaches. There can be recalls, there can be pile-on lawsuits, there can be regulatory actions. There can even be shareholder derivative cases where shareholders say, you management fell asleep at the switch, and as a result of this and failure to implement reasonable safety and product quality controls, we lost a significant amount in our investment. So shareholder claims brought after a very high-profile product liability claim are not uncommon. And then, of course, the media exposure once this gets out into the Twitter sphere. So enough about the problem. Let's pivot to try to talk about the solution and what we can do to avoid this parade of horribles. There are three risk mitigation steps that relate to product liability cases that I'd like to touch on very briefly here. The first may seem like a bit obvious. Okay, I came to this seminar for you to tell me that I should have insurance. Having insurance is obviously the first step to avoiding or mitigating against these risks. But I want to sort of dwell on this nonetheless for a few moments and drill down to some permutations of this concept that may be worth pursuing a little further. It's not just insurance, first of all, that we're talking about. It's indemnity rights in connection with a contract. So for the most part, almost every product that is distributed of any significance involves, as I've said before, component parts. Either you're buying some plastic or material that's put into your product or that's used for your product, or your product is a component of a larger product. And then there are also chain of distribution contracts. Think about whether in this stratosphere of contracts and relationships, you can obtain some indemnity protection from those that are providing products or components to you, including raw materials, that you could then, if a claim arises, that the raw materials that are provided to you are defective or have some chemical in them that's causing injury, you can tender that claim to that provider. Now keep in mind that your retailers are probably going to be thinking the exact same thing with respect to you. So most retailers in the U.S., if you're going to put your products on their shelves, they're going to require you to indemnify them if they're sued on a product liability claim or other claim. Reviewing those contracts for the indemnity protections is a very good idea. It's also a good idea to think about perhaps being an additional insured on a policy that one of these other partners in your constellation of relationships obtains for themselves. Think about, for example, the scenario where you are using some sort of plastic from China, and what is your recourse if that plastic, if some variation from the specs, notwithstanding all the assurances that you've been provided, turns out to have some chemical in it that is harmful to consumers? As a practical matter, are you going to sue them here in Canada? Are you going to sue them in China? If you obtain a judgment against them, are you going to be able to ever enforce it? Obtain some sort of policy from a domestic carrier that covers that act or omission and then includes you as an additional insured. So that might be a good idea to think about with respect to foreign suppliers. So there are a whole variety of issues that you can focus on relating to both insurance and indemnity rights. The second maybe also seems too obvious to mention, but I think it bears emphasis as well, and that is engaging in a whole battery of tests and analysis of the product, making sure that all of the toxicology reports, the material safety data sheets are reviewed and are assessed to make sure that all that documentation is in order, and make sure that the people that are receiving that information back really understand the significance. The reason is because the only thing that's worse than not having this testing is having testing that creates an issue or raises a red flag and someone doesn't understand the significance of it and files it away. So I speak from a litigator's perspective, since I've spent almost my entire career defending cases in product liability and other types of lawsuits. And so I have a pretty good sense of what types of discovery are permitted and what would be thought of by a court as overbroad. And I can assure you that in a product liability case, a request for documents along these lines, please produce any and all documents relating to any testing performed on the product by anyone, including but not limited to your R&D department or any third-party consultant, that's going to be allowed. And there's very little I can do to narrow that or object to a request along those lines. So that's a very important focus and involves a lot of discussions with R&D and with your outside consultants. The next area, and the third and final area under this product liability heading relating to risk mitigation steps, is escalation of customer complaints. You have a customer service department, and sometimes I think the customer service department's focus is just making the customer happy and satisfying this customer, and then that fire's put out, and the customer is happy with the replacement or whatever accommodation's been provided. The customer service department can be a very important first line of defense, early indicator as to detecting and preventing larger claims. And when you start seeing trends, you start seeing a number of complaints, you start understanding that this may represent a larger issue. And so make sure that you've got someone in the customer service area that is cognizant of these types of indications and is creating a very appropriate record of the issue. Not disparaging the customer in an email that could later be discoverable. Hey, this customer is complaining about this issue and I don't think it's an issue, and saying something that you would not want to come out in discovery. Because again, as a litigator, I can tell you that a very typical document request in a product liability case is something along these lines. Produce all the documents that relate to other customers' complaints that are similar to my own complaint. We might be able to push back a little bit and try to narrow this, but in the main, a request along these lines is going to be permitted. And you end up, in some of these cases, having lots and lots of emails and documents that in hindsight look really, really bad. They look like someone was ignoring an issue that would have been a red flag, and the reasonable company would have been all over this and recognized we have a systemic problem. Consider attorney-client privilege issues when it comes to these type of analysis and whether to involve counsel in analysis of these claims because you may be able to protect some of this information. So we've now completed our first of the four categories of product liability claims. We're going to pivot from the law of torts in product liability to the law of contracts. If the product has not caused injury to person or property, for the most part, the customer's complaint, but it's still an issue with respect to the product's performance or capabilities, the customer is going to be relegated to the law of contracts. And in the United States, that, for the most part, comes under the Uniform Commercial Code, which is a standard body of law that has been adopted in all states except for Louisiana, which still follows the Napoleonic Code. The UCC has within it Article 2, which governs the sale of goods. And it's very analogous to the UN Convention on Contracts and the International Sale of Goods. Many of you are probably more familiar with that than the UCC. Our focus today within Article 2 of the UCC is going to be on express and implied waivers and the disclaimer of those waivers. And as a seller, you're going to want to disclaim as many, the disclaimer of those warranties. And as a seller, you're going to want to disclaim as many of those warranties as you possibly can. And the remedies of the buyer. Express and implied warranties are a significant issue when it comes to creating the documentation by which you're selling the product. A warranty is really nothing other than a promise that a buyer makes to a seller about the product. It can be either express or implied. Express warranties can take a variety of forms. It need not be in the contract under a heading that says warranties. It definitely includes that, but it's not limited to that. It can be essentially any statement made by the buyer or that is attributable to by the seller or that is attributable to the seller. It can be the glossy brochure that marketing put together and sent out without legal review. It can be the overzealous salesperson who wants to get that trip to Tahiti at the end of the quarter and is so desperate to make a sale that he or she whispers in the ear of the customer, never mind the limitations and the specs as to what the brochure says the product can perform. This can go way beyond that. We have those type of issues all the time. Implied warranties are, as the name would suggest, not necessarily stated in express terms, but in every sale of a product, there is an implied warranty of merchantability, and in some instances, there's an implied warranty of fitness for a particular purpose. So when someone comes and says, this is my need, and this is what I am trying to do, and you or someone acting on your behalf says, we have just the widget for this, then you have perhaps an additional implied warranty. What you want to do, to state the obvious, and again, as a seller of products, you want to try to disclaim as many warranties as you can without essentially scaring the customer away and saying we're making no promises. It's very important, as I said before, to understand whether your customer, the buyer, is a commercial entity or is a consumer. If they are a consumer, then they have a significant amount of protection under state and federal law that essentially says we're not going to allow sharp business practices with fine print on the reverse side of an invoice, or with now more often fine print that's buried on a website somewhere and that you're saying is part of the contract, to disclaim all of these warranties. We're going to take care of this type of abuse. And so there are significant limitations. I've listed a number of statutory provisions, again in California, that talk about the clarity of the warranty language, that talk about the need for having replacement parts available and repair facilities available. And that in addition to imposing all these substantive requirements on a consumer contract in the warranty area, also have significant remedies if there's been a failure of the warranty, a willful failure by the seller. This can include treble damages. So you take the amount of damages that are allowed under the contract and you multiply it by 3 for a willful violation. And of course, attorney fees. These types of claims are brought also as class actions quite frequently. You put out a product, let's say it's a laptop computer, and the warranty says that it will perform and has a 3-hour battery life and has a 2-hour and 45-minute battery life. You have essentially a promise that's been made, and you have a violation of a term of a warranty, and you might have a number of people that have complained about this, and then all of a sudden you receive a consumer class action which seeks to aggregate the claims of thousands and thousands of consumers who have bought this product and relied on this warranty. So these can be very, very significant cases, and when you add the attorney fees in a class action, it can be quite a significant liability. The remedies of the buyer in the business-to-business context can be limited. You have a lot more freedom of contract in that context. And you can essentially say your only option is to repair or replace this product. You don't get punitive damages because we're in the law of contracts, not the law of torts. So that's a good thing. The bad thing in a B2B consumer warranty, or I'm sorry, B2B warranty context, is that you can get, the buyer can get lost profits. So it would be a misunderstanding of this area of law to believe that the potential liability in this B2B warranty context is not significant because it's, you don't have all these consumer protections that you get in the consumer warranty area. There can be millions and millions of dollars sought when a product has failed and has resulted in a loss of business. Think about a big piece of commercial equipment that you've sold. Think about product that you sell to someone else that has to be subject to a recall. And they get all of the horrible publicity and the loss of their market share as a result of having to recall that product. So there could be millions of dollars in lost profits. Risk mitigation steps in the area of warranty first involve the three things we talked about under product liability. Again, it's insurance, it's number one. Number two, it's your customer service. And number three, it's your testing and your third-party analysis of the product. So obviously you do all of that, and then you turn, those are sort of the non-contractual risk mitigation steps. Then we, of course, turn and focus on the contract terms to maximize your contractual protections and sort of put within a reasonable limitation the contractual remedies that the seller enjoys. And of course, again, you have to determine whether you're dealing with a B2B contract or a consumer contract. There are 8 ideas for inserting robust contractual provisions in the B2B context, and I've listed them here. And for the sake of time, I'm just going to skim over them very briefly so that we finish on time. First, as I said before, you can disclaim your implied warranties, and so you need to figure out how to have effective disclaimer language. Disclaimer language needs to be conspicuous. Sometimes courts dwell on the issue, and even some statutes dwell on the issue of font size, whether it's on the reverse side of a contract and not pointed out, whether it was initialed by the customer. So I like to see disclaimer of warranties in all caps, bold, font. But you need to make sure that you, to the extent possible, have disclaimed implied warranties. The battle of the forms is something that we deal with a lot in commercial B2B context. So how does this happen? I'm the seller of a product. I send it out. I've got my warranty language here with all the effective disclaimers. And so it goes out with an invoice, and the seller turns around and has a purchase order, and their purchase order is equally very well drafted, and they essentially say, no matter what's in your invoice, our purchase order governs, and then we have what we sort of, I think, very cleverly call the battle of the forms. And they're canceling each other out. They're both claiming to be the terms that govern the relationship. You can address this through a master supply agreement that says that the parties will not, that the terms are within the four corners of this document, and that no matter what documentation is exchanged, nothing else is part of the contract other than what's in these documents, and for example, the specs that are attached. These are the only warranties that are provided. In that vein, it's also very helpful to have an integration clause. Integration clause basically says, this is the entire agreement. And it doesn't matter, I mean, it doesn't say it like this, but it doesn't matter what the sales rep said about the product, that it can go much faster or as much safer or as much more effective. These are the specs, and you cannot add any specs to this unless they're in writing, signed by both parties. Of course, reviewing those specs to make sure that they are accurate and that the product conforms is also very important. Limiting the remedies to repair or replace, and this is most important, perhaps most important. Make sure that you effectively state no lost profits, no other consequential damages. Your remedies are that we'll repair and replace, that's it, period, full stop. Again, think about issues that come up with component parts. Packaging relating to food can be a significant issue if the packaging doesn't conform to specifications or arguably creates an issue. Arbitration provisions can be very helpful. We'll discuss those a little later. Form selection clause. Make those parties, those commercial parties, come here to beautiful Calgary and arbitrate their claim in a private arbitration with your friends and colleagues here in Calgary, if you can get by with that. And that your more favorable laws would govern rather than perhaps U.S. law if comparison merits that choice of law. If you're selling products in significant quantities, thousands of widgets, a lot of 1,000 widgets at a time, Think about acceptable quality limits that say, look, we're going to have a dud. You know, 1 out of every 5,000 of these is going to be a dud. Make sure that you think about perhaps an allowable failure rate when you're selling thousands of widgets in a lot. Also, if this is not listed here, but it probably should be, if you're selling a component part that's going to be put into a larger product, think about whether the contract should have a provision that the party that's incorporating your component into the larger unit has a duty to inspect, and that they won't put a defective product into the larger unit that's going to cause a problem. So what are the inspection obligations of that party? You see, every time we involve, you know, component parts, we go from like a game of checkers to a game of 3D chess, because we have all of these relationships, and we have contract terms, and it ends up being very complicated when you move from a single product analysis to components. To the extent that you can, review all of the warranty and contract language when you're in the consumer product context, and ensure that it complies with the laws of the jurisdiction where you're selling the product. Make sure that if you're selling in California, that you've taken into consideration the California Consumer Warranty Act, the Song-Beverly Act, and I had a bunch of the sites that are listed in a previous slide. It's also very important when you're selling to consumers that you have an effective contract. How are the consumers receiving the product? Are they ordering online? Do you have a warranty card that they're sending back, which establishes and helps solidify the existence of a contract? Do you have your terms and conditions just passively on your website? Click wrap versus browse wrap are the terms that are used to discuss this concept, where you put the terms and conditions, including to the extent that you can, you know, limiting remedies and even perhaps a consumer class action waiver on your website. But when they go to buy the product, are they clicking on something that expressly highlights that? Courts are going to sometimes draw a distinction between click wrap and browse wrap terms. All right, we're moving right along, and I think I'm on schedule here with respect to the third category of claims. So this relates to the statements that are made about the product, statements that are made about the transaction that you're involving the consumer with. These claims are, for the most part, in the consumer context. Not a lot of false advertising claims brought in the business-to-business context. And the liabilities that are often multiplied in a consumer class action. So there are 3 California statutes that sort of work together. On the defense side, they're referred to as the unholy trinity of regulations that really focus on protecting consumers from deceptive advertising or sharp business practices, including by those that are selling, distributing product. And they work together. The false advertising law, the Consumer Legal Remedies Act, which has 27 prohibited practices, and the unfair competition law. The unfair competition law is very interesting because it essentially says, in very unremarkable terms, that a party can get an injunction against any business practice which is unfair, fraudulent, or unlawful. And what this does is this last predicate, which is unlawful, essentially creates a scenario in which any violation of any regulation can be the basis for a claim for injunctive relief under the statute. So it doesn't matter if the statute is a federal statute or a state statute or some obscure regulation. It doesn't matter if the statute does not have a private cause of action. So in other words, if it weren't for this statute, for the UCL, one could not bring a cause of action for a violation of this regulation. It allows someone to essentially say, by virtue of you violating this other law, I have a claim under the unfair competition law. So then we have that UCL unlawful act predicate, which is then coupled with a host of other regulations, including the Federal Trade Commission Act, which in very broad and somewhat amorphous terms prohibits deceptive, unfair and deceptive acts or practices affecting commerce. And then the other federal law that comes into play here is the Lanham Act. And this is what we talked about a little earlier. The Lanham Act is often used by competitors when you are either through your trademark violations or false designation of origin claims, or just making false representations and statements about your product or describing the product, are injuring not the consumer or the customer, but you're injuring competition. So Lanham Act claims are also a very significant federal law that sort of works in with all of this, and these are brought together sort of working off of one another. And so what we have then is we have a number of, for example, at the FTC level, a number of new guidance, new statements addressing very specific industry abuses. And these FTC statements or policy guides then become the predicate for a consumer class action. And the consumer says, look, the FTC has said that this practice is very sharp and it's harmful to consumers, and so I'm bringing a claim to enjoin this practice. And so you have a state claim that's predicated on a federal statute or a federal guidance by a federal regulatory agency, which can only be brought in California because California is one of the few states that allows a plaintiff to circumvent a federal statute that doesn't have a private cause of action by essentially alleging that it's unlawful under the unfair competition law. So there's a bunch of sort of academic wrangling to get there, but that's essentially how all of this works. Again, these are consumer class actions. I think most of you are familiar with the concept. I know you have class actions here in Canada, but it's essentially the aggregation of lots and lots of claims together and essentially claiming damage, even if it's in a small amount, that when added all together ends up being sometimes a very significant number. So there's 5 factors that we need to think about when we think about false advertising claims, and here they are. What are you saying about the product, right? I'm sorry, what are you saying about the price of the product, the sales, the discounts? What are you saying about the product itself, which is sort of an obvious one? What are you not saying about the product? Think about fraudulent omissions. What are you saying about the transaction itself? And how is the advertising statement conveyed? So let's break this down. What is said about the price? And you will see here there are a lot of citations to federal and California law that address very specific violations, and you can drill down and obtain a better understanding of each of these to the extent that it relates to your particular practice or your business. Be aware of false discounts, the perpetual sale. Sometimes I talk to retailers about a company that's always going out of business. They always have a sale. Putting a higher price on a product that's not the real product price, so that you can say this is 50% off, 70% off. That can get you into trouble. Bait and switch, when you essentially lure a consumer to buy one product and then you're essentially saying, oh, in order to get that price, you have to couple it with this. Sending something out as a gift or a freebie, when in fact it's really a sale. And the reason it's a sale is because you've got a shipping and handling charge where you're essentially recovering a good significant amount of the what would normally be the purchase price. So it's really not a sale, but you're marketing something as free or as a gift. Comparative advertising is another very important area where we're talking about what is said about the product, the second category that can get you in trouble. And we talked about the Lanham Act case, the Lanham Act claims, but it's also one of the 27 prohibitions under the Consumer Legal Remedies Act. Be careful when you start comparing your product with your competitor's product. It's sort of a natural hesitation that I think you should have because it's going to get the attention of the competitors. Be very careful when you start disparaging, and you can provide opinions, but when you start using facts to disparage another product or to do some sort of comparative advertising that could end up bringing one of those claims, including a common law claim for trade disparagement. Further, what's said about the product, there are some specific prohibitions listed here, but if you're in the food space, very, very significant spate of class actions in California right now that have to do with advertising some food as being all natural, organic, all the things that my wife emphasizes when she sends me to the store, and I say it's just another excuse to mark up the product. All of those things can be subjected to a claim that you're advertising something as being not what it really is. There's some litigation relating to microbrews and what constitutes a beer that is a microbrew versus brewed like all the other mass-produced beers. Artificial sweeteners, a very significant issue right now in class actions in California. Origin is another very significant issue relating to product liability claims. Here we're talking about not just the made in the USA claims, which there have been a number of cases involving what constitutes being made in the USA when you have components and assembly and a complicated question. But also if you're importing something from another country and you think there's some marketing benefit from saying it comes from that country, make sure that there's justification for that. False designation of origin cases. Another issue that consumers are increasingly aware of and that there's some relatively new legislation in California on are statements made about the fact that the product is not produced with slave labor, that there's been fair and ethical treatment of workers in connection with the product. There are affirmative statements that have to be made under the California Transparency in Supply Chains Act for some companies selling products in California. There's not a private cause of action for violation of the Transparency Act, but again, under the unfair competition law, if you make a statement that is not true, then it can be a violation under the UCL because it's unlawful and also because it's fraudulent. So this is a significant issue for consumers. Greenwashing is an issue that we've seen a fair amount of activity in recent years, both regulatory and in litigation. Everyone wants to buy the eco-friendly product. And so make sure that when you say that your product is eco-friendly or has those qualities, that you can back that up. Any of these type of statements can be relied upon by a consumer and therefore subjected to potential product liability claims. What is not said about the product is also a very important consideration, omissions. Again, the failure to warn about a product that it might not be suitable for children can not only be a product liability claim if injury actually occurs, but it can be essentially a false advertising and marketing claim by virtue of the omission. And here, of course, we have to emphasize Prop 65 in California. Show of hands, anyone here familiar with Prop 65 in California? So Prop 65 is a reason that in California, when you walk into a Starbucks coffee shop, you see a sign while you're standing in line for your cup of black coffee that says, drinking coffee has been determined by the state of California or coffee has been determined by the state of California to contain carcinogens and chemicals known to cause cancer or reproductive harm, something along those lines, just to buy your cup of coffee. It's also why every time you open up a box, there's a Prop 65 label. So what it is, it's a statute, is actually passed as a proposition that essentially says, we're not going to regulate the chemicals you use and put in your products, but if you use chemicals that are on this list and have this exposure level, you have to issue a warning in clear and conspicuous language to the consumer, letting them know that the product contains these chemicals which are known to cause cancer or reproductive harm. And there's a ton of litigation relating to Prop 65 claims. There's a whole cottage industry that has developed which sends out these pre-lawsuit demand letters, waits 60 days, and then brings these actions. And the penalty for violating Prop 65 is $2,500 per violation. And yes, that means per product that you sold. So all of a sudden you can face a very, very significant potential liability under Prop 65. So testing products with a special emphasis on Prop 65 exposures is very important. It's that to the power of 10 if you're selling to kids, because kids put things in their mouth all the time. If you are ingesting, if it's a product that is to be ingested or comes near the mouth, very significant potential liability. So Prop 65 falls under the failure to warn category. The fourth is what is said about the transaction. So think of here about your money back guarantees, what a customer has to do if they're unhappy. Another issue under the transaction has to do with if you're going to add shipping and handling charges. You have to be aware that some consumer class action plaintiffs think that it is an unfair business practice or deceptive practice if your actual shipping and handling charges are not the same or equal to or less than the shipping and handling charge. In other words, the claim is that this is a little profit center where you make a few extra bucks by an increased shipping and handling charge that you tack on at the end of the transaction, at checkout in the e-transaction. And so they base this in some language in the Direct Marketers Association guidelines that discourages elevating a shipping and handling charge above the actual amount disclosed. I like to emphasize here also these opt-in, opt-out buyers clubs that have become very popular. Where a box of clothes ends up at someone's doorstep every month. Someone in my house is enrolled in one of these beyond my control, and it's not me. Make sure that you have very clear ability to opt out and terminate those types of buyers clubs and subscription programs and disenroll. The fifth advertising marketing claim relates to how the advertisement is conveyed. Are you spamming your customers? Obviously a very significant issue. Are you calling your customers or texting them on a cell phone? Significant liabilities for a lot of those types of practices. Are you marketing to children? There are obviously a great deal of concerns about marketing to children and getting their information online. Are you using social media to advertise? And are you aware of some of the recent concerns about essentially undisclosed advertising, native advertising, where you're paying someone that has 50,000, 500,000 followers on Instagram to use your product, but you're not telling them that they have to disclose to their 500,000 users that they are receiving consideration from you or compensation from you for advertising. Paying bloggers to provide a great review of your product is another issue. There's also issues with respect to your website and making sure it is accessible to those that have disabilities. A flurry of cases in recent years on that. So there are some risk mitigation steps that you can take under this category of claims. Use the regulations that I've outlined as a checklist. Some will not apply at all to your particular business. Others may be of great interest. But I would also suggest spending some time and perhaps even engaging someone to conduct a thorough research of the litigation activity that relates to your industry, your particular space. What are your competitors doing that has, put them into a little bit of trouble? And rather than just taking some satisfaction in their misfortune, try to figure out how to learn from their mistakes. In this area, it's very important to have complete buy-in and support from those in your marketing group. And sometimes I think that those in the marketing group and the sales group are not completely tied in to the legal liabilities that they are creating by their sales practices. So make sure, obviously, that any marketing that goes out is reviewed by in-house counsel or outside counsel to ensure that it's not going to create one of the problems that we've identified. We've talked about insurance, but with respect to coverage, you want to make sure that you have some sort of coverage that includes advertising injury. Remember, here the product hasn't really caused a harm. It's just been subjected to a claim of false advertising. And so there's coverage that can be obtained that would include those types of claims. We're to our fourth and final of the four categories of claims, so I hope you are not overwhelmed by everything at this point. And I will go through this quickly. This is an area that you probably have received a great deal of information on and perhaps gone to seminars devoted to this entire area. But I think it bears emphasis here because if you're selling products to consumers in particular, you need to be aware of the potential liabilities that are created by receiving, cultivating, I think the word that's often used is curating all of the personal information that you're going to be obtaining over time. This includes, of course, credit card numbers, social security numbers in some instances, usernames and passwords. If you're going to then use information, personal identifying information that you've obtained in the ordinary course of just being able to contact the customer, and you're going to use it for marketing back to that customer, whether it's you using it or providing that data to a third party, be aware of those increased risk. This very important to realize that some companies have thought that by de-identifying consumer data, they can sell it to a third party. And I think the law is very unclear on that. In other words, you take out, you want to, the data has some value to it in that it shows trends, it shows, you see this in the pharmaceutical space, for example. It shows what customers are buying, or in some cases doctors are prescribing. And you know that you can't just provide that private information to third parties, but you can take out some of the information that would allow someone to identify, address, name, and so forth, social security number. You take that out, so it's called de-identified, and then it's repackaged and it has some value to industry. So even de-identified data can create some issues here. Then when you go to dispose of the data, whether it's getting rid of an old computer or photocopier or other hardware, you need to think about whether you're doing that in a way that is protecting the consumer's data. Obviously, if you're in the medical or financial arena, there are a whole host of protections that are unique to that space. So I'll let you pursue that on your own. But those are kind of the two most detailed bodies of regulation that have to do with consumer privacy. Here are some more garden variety regulations that relate to consumer privacy when you're communicating with consumers through their computers or their smartphones. just the collection of personal identifying information from a consumer's computer can create potential liability. You must provide sufficient notices of your privacy policies. You must avoid, robocalls, and there are both state and federal statutes relating to that. Telemarketing, sending text. Another area in this is, which of course could be its own seminar and is often covered in extensive presentations, is when you haven't done anything wrong here, but as a result of a third party that's hacked into your system, all of the information of the consumers is now out there. So obviously that deserves a great deal of attention. Be very aware of notification requirements. Even if you haven't done anything wrong, under some circumstances, you're required to make certain notifications, both to the consumer, who now needs to know that their information is out there, and in some instances to the regulators. If you have a product that is itself a smart product, the Internet of Things, is communicating through Wi-Fi, is gathering information, there are significant issues and risk relating to all of that data, how you're using the data. And this is going to be increasingly an area of great concern, and regulators are focusing on this. So if you're in the brave new world of Internet of Things, that deserves special attention. With respect to consumer privacy and data claims, I think you should sort of start with this framework. What type of data do we have? What are we doing with that data? What are we doing to notify consumers of what we're doing with their data? How are we protecting against the data being hacked? And are we ready for some horrible crisis that is obviously going to happen on the first day of your vacation or on a 3-day weekend that's going to call in, the most important people in the company to try to get their arms around. 15 types of data comes from the FCC's Cybersecurity Planning Guide. Great checklist to include. Walk through and say, which of these types of data do we have, and what are we doing to protect the data? I'm going to close with sort of a recap of 5 risk mitigation steps, and I don't have time to do this justice, but there is an article that I recently wrote under tab C of your handout, avoiding unnecessary U.S. litigation risk, that is centered around these 5 steps. Choosing a forum and understanding how personal jurisdiction works in the U.S. You can't avoid, particularly in a product liability case, being brought into court in the U.S. if you put a product in the stream of commerce. But in a lot of other contexts, you can be very mindful of the contacts you have with the foreign jurisdiction, including California, and ways to avoid subjecting yourself to jurisdiction in California. In this area, it's also important to think about whether you can obtain a class action waiver through an effective arbitration provision. And this even is permitted in the context of consumer class actions, which is a relatively recent development from the U.S. Supreme Court in a case called AT&T versus Concepcion that says that consumer class action waivers in arbitration provisions are permitted, much to the chagrin of the plaintiff's class action bar. The second is limiting the amount of time in which a claim can be brought. There is such a thing as a contractual provision that works almost like a contractual statute of limitations, or the period of the warranty. Think about those issues. We've talked already today about limiting the remedies in certain contexts to repair and replace, and liquidated damages clause, disclaiming lost profits, and so forth. And then, of course, what we talked about at the very beginning, using indemnity provisions, insurance coverage to shift that risk to third parties. And then, of course, creating a crisis management plan that what happens if that foresees the day when we have to do a recall on short notice. And we've got all these products that are now out there in the market, and we have consumer complaints, and we've got to do something very quickly. And this, of course, includes social media disasters, which can go viral, in a matter of minutes. I think it was, none of us had ever heard of the word covfefe until yesterday, right? To illustrate how quickly something can go viral. So that's the entirety of the presentation. I wish it was a little more cheerful than it is, but there are significant steps that can be taken to reduce these risks, strategize about how to avoid unnecessary litigation. And at this point, to the extent there's time and interest, I'll be happy to answer any questions that anyone may have, or hear any comments that anyone may have. Yes, in the back.
You mentioned the AT&T case and how that was a bit of a setback for the plaintiff's bar. Another tactic that expected defendants sometimes use is choosing the forum, especially in contracts of adhesion.
Yes.
In the U.S. context, are the courts taking the same mindset that they're very pro-defendant in enforcing forum, arbitration clauses and things like that, or are they tougher in that respect when it's consumer-driven litigation?
Forum selection clauses, no question, applied without, almost invariably in the commercial context, and as this pattern that you've heard in this entire presentation, much greater protections for consumers. But you can, in consumer contracts, have a forum selection clause, provided that it is not unconscionable. So it's determined by an unconscionability standard, and how harsh it would be on the consumer to litigate that particular claim in another forum. I think that the best combination is a forum selection clause with an arbitration clause included. Because particularly if the arbitration clause says that they can arbitrate in a more local area. So I would be more concerned about getting them into arbitration than in their neighborhood than forcing them to go from California to some distant city. And besides, it's a lot easier. I mean, if you can get a consumer to a single plaintiff arbitration, you're halfway there, or more than halfway there. Yes?
To what extent are you liable for product liability to consumers if you offer your product for free, for example, a free app?
Free, I don't think, has anything to do with whether or not there's a product liability claim, because product liability is based, most of the theories are based in, or can be based in tort rather than contract. And so privity of contract is not required, and so the fact that it's being given for free would not be a defense, unfortunately. Yes?
Another question on that line, speaking of privity of contracts. Say you have a software that you require all users to sign a click-through agreement before they use that software. How enforceable is that if you've already contracted with, we contract with different government entities in the United States. So we'll have a contract, say, with the U.S. Forest Service, and then all of the U.S. Forest Service staff will sign a click-through agreement. Are those terms and conditions enforceable, or with the first agreement with the U.S. Forest Service that's sort of the contract about how much we're going to spend for this software?
Well, they'll probably be viewed in tandem together. And then you only have an issue with respect to if there are conflicting terms. But I think it's best in all of these situations to have a master agreement, a master supply agreement that says that this is the total agreement, and it really, all the other terms and conditions, either on your purchase order or our invoice, or that can be exchanged between the parties, are really immaterial. this is the contract, rather than, a whole series of contracts. It makes it much easier. Okay. Any other questions? All right. Well, I want to thank you again for coming. I hope it's been informative. I hope the materials might even be of use in the future if you put them on your bookshelf. And I'm happy to follow up and have a conversation with anyone if you want to stick around. So thanks again, and have a great morning. Thank you.